Hello, Facebook. This is attorney Michelle Lebron. I am live for the first time on my Lebron Law page. I'm going to talk slow and give folks some chance to log on. In fact, I think I'll go online and let everyone know I'm live, although you probably already get an update letting you know that I'm live. So we're just going to give some time for some viewers to log on. Okay. And just to let you know, today's topic is going to be fathers' rights in Florida. I'll talk for a few minutes about that, 15 minutes or so, and answer any questions that you may have. If you're watching me live, go ahead and send a message and let me know who's watching so I can give you a shout out. My darling son keeps texting me, so it's coming up on my page. So go ahead and post a comment so I know who's there and I can say hello to you. And like I said, I'm going to go on my page and let everyone know. Let everyone know that I am live. And so, like I said, we're discussing fathers' rights in Florida. Hey, Lewis, thanks for logging in. Good to see you online. We have to get together soon. And so my name's Michelle Lebron, and I'm an attorney in Florida. I'm licensed to practice law in Florida and in the state of New York. Today's topic is going to be fathers' rights in Florida. I'll post a video another day for my New Yorkers, but today we're talking about Florida. I posted an ad on my Facebook page a couple of weeks ago with the title, "Got Baby Mama Drama," and I had an enormous response, an overwhelming response, because there's so many men out there who don't realize that they actually do have rights. There's a very common misconception that fathers don't have rights. Okay, so we're located in downtown Kissimmee, Osceola County, right behind the Osceola County Courthouse. And if you are already a client, stop in and say hello sometime. And if you are not, I encourage you to contact my office and speak to my assistant, Mirta. We can be reached at 321-800-5195. And Mirta's happy to schedule an appointment for a consultation for you to discuss your custody and time-sharing issues. Florida doesn't use the term custody and visitation. Florida calls it time-sharing. So one of the things that you need to understand is that Florida has a very strong public policy that children should spend time with both their parents. And you may think that, I hear a lot of men say, fathers have no rights. And that is just not true. You do have rights, you just need to assert them. And what you need to understand is that when you have a child out of wedlock, the mother is the natural guardian of the child. And although you sign the birth certificate, that's not enough to make you the legal father of the child. And paternity is not established until there's an adjudication by the court naming you the legal father of the child. And so there's a few ways that that can be done. And I see a few more people logging on. Go ahead and don't be shy. Send me a message. Say hello so I know who's watching and I can shout you out. There's a few ways that, few things that you need to do in order to establish your paternal rights. If you received a letter from the Department of Revenue and child support is being established for the child, that's not enough to give you time sharing. And a lot of fathers feel that they're paying child support and they should need to be able to see their child. Hey, Adam, thanks for logging on. Thanks for logging on. So if they're paying child support, they feel like they need to be able to see their children. And in order to do that, you need to file a petition to establish your time sharing with your child. One of the things that does also is once time sharing is established, it will lower your child support if you have a substantial number of overnights with the child. So it's really important that if you receive a notice from the Department of Revenue to start a child support case, you should contact an attorney, contact my office. We're happy to help you to get that petition rolling so that you can establish your time sharing rights. So under the Florida law, as I stated, the mother of a child born out of wedlock is the natural guardian. The mother is entitled to primary residential care and custody of the child during that period of time until you assert those rights. And what that means is that if you try to call law enforcement to help you see your child, there's nothing they could do. And if the mom threatens to move out of the state, mom's free to move out of the state with the child until you go ahead and file that petition for paternity and get your paternity established. She cannot be ordered to return to the state if you don't have an adjudication of paternity. I see some more folks logging on, so go ahead, don't be shy. Say hello so I can shout you out, let you know who's online with us. Thanks for logging in, everyone. So we can, as I was saying, you can't force mom to come back to the state if there's no order of paternity. So what you need to do is contact my office, schedule an appointment to come in for a consultation. Hey, Tony. Hey, Jesse. How are you guys? What you need to do is schedule an appointment for a consultation. Come on in. Some of the information that you need to have available to you is the name and address of the mother of the child and the child's date of birth. If you have the child's social security number, that's helpful. If you don't, I understand. It's not a problem. Sometimes it's hard to go ahead and get that information from mom. Hey, Sheila. Thanks for logging in. So sometimes it's difficult to get the social security number from mom because they think that you're maybe up to no good with the social security number, and that's just not the case. But so those are some things that we need from you: mom's name, address, child's name and date of birth, and any other information you have pertaining to the child, such as whether or not the child has any special medical needs or is on medication or anything like that. Any information you can provide about the child. If you are confident that it's your child, you don't necessarily have to have a paternity test. But if you're not sure, then we can ask the court to order a paternity test, which involves us filing another motion and having the court go ahead and enter an order ordering mom to present the child at a DNA testing site. And you can get that DNA test done. And once it comes back saying you are the daddy, we can proceed with the case. If you are not the father, then the case would be dismissed. So those are some of the basic things that you need to know when you're getting ready to establish your paternity. Once you are able to establish paternity and get a parenting plan entered, a parenting plan is a document that's going to set forth the days and times in which you're going to spend with your child. And once you're able to go ahead and get that entered by the court, mom can't control anymore the days that you see the child. So there's a lot of times you're calling, saying, requesting to see the child, and mom is telling you, oh, sorry, mom's mad at you today, and so no, you can't see your child. Once you have that paternity plan in place, all of that stops. If mom goes ahead and violates that parenting plan, then there are additional steps that we can take with the court to have the court enforce the parenting plan and have you be allowed to see your child on the days and times that were agreed to. So I will leave it at that for paternity for today, and I will log in again soon and talk to you about child support and how child support is calculated. If anyone has any questions, you can go ahead and I'll wait a minute so you can type a few type of message to me. If you have a question that I can answer now, I will go ahead and try to answer that for you. This is your time for free. Oh, and I should say, I have to give my disclaimer. This is not legal advice. No attorney-client relationship is formed by you sending me a message through Facebook or email. An attorney-client relationship is only formed when you sign an engagement letter with me and pay a fee. And as it pertains to fees, our firm is quite flexible. Everyone can afford an attorney. Don't think that because you earn a certain wage that you can't afford an attorney. We're very flexible and happy to help you with a payment plan so that you can have your rights to see your child as necessary. So we're happy to help you with that. So if no one has any questions, I will leave it at that and log back in with you another day, and we will talk about child support and how child support is calculated. And so I have a question. Recently, I had a customer come into the dealership saying she could use her child support as second income for her car payment. Can they do this? Child support, I believe, may be calculated as income. I'd have to do some research for you, Adam, and get back to you with that, an answer to that question. I mean, technically, you're supposed to be spending it on your child and not buying a car with it, but I can do some research for you and figure out if that's possible. And I have hey, Michael, I have another question for Michael. Hello. How common are fathers able to get full custody of their sons? Well, in Florida, Michael, it's not that easy to get full custody. You'd have to show that the other parent is a detriment to the health and well-being of the child. Generally, Florida orders shared parental responsibility, just as general, unless the other parent is, like I said, detrimental to the child. And you would be looking at going to a full-blown trial on that issue because mom is not likely to want to sign over parenting. And I should explain that in Florida, we don't call it custody anymore. It's parental responsibility, and visitation is called time sharing. So in terms of parental responsibility, Florida generally orders shared parental responsibility, which means that both parents have equal rights to major decision making for the child, such as education and medical decisions and things of that nature. So I hope that answered your question. Any more questions? Well, I'm happy that everyone logged on. If you know a father who's dealing with an issue like this, who's maybe paying child support and not seeing his child, or isn't paying child support and isn't seeing his child, please share this video with them and have them contact my office, and I'd be happy to have a consultation with them. I do offer free consultations. Be happy to have a consultation with them and let them know where they stand. Oh, one more question from Anna. Hey, Anna, what if the mother is not involved? What do you mean if the mother is not involved? If the child, who is the child with, Anna? Just give Anna another second to type her question. So I was saying, answering Michael's question earlier, that generally Florida orders shared parental responsibility, which means that the two parents equally share the right to make major decisions for the child. And Anna, you're typing slow, Anna. What if the mother, okay, dad and she comes around whenever she feels like it. So is the child with another family member besides the parents? If that's the case, Florida doesn't interfere. They found you have a constitutional right to raise your children. So if the child is currently being raised by some other family member, mom and dad can come and take the child back whenever they want. Unless you're able, if maybe possibly DCF gets involved and maybe says, that the parents are, that they need to shelter the child Okay, so child is with dad and his parents. Okay, dad still needs to go through this. If dad has not done this and the child was born out of wedlock, then dad still needs to go through this procedure. He still needs to have paternity established by an adjudication of the court. And then if mom's not around as frequently, she may not, most of these cases go to mediation first. So she may come to mediation and just agree to a time sharing schedule of what they have right now. If she doesn't agree voluntarily and you have to go to court on the issue, there are certain factors that the court considers when it's making a time-sharing determination. And one of those factors is the stability and continuity of the child. So if the child's been with dad for a substantial period of time, then it's not likely that the court would take the child away from dad altogether or give mom substantial time-sharing. So it all depends on the age of the child. And each of these cases are very fact-specific. And the family court judges have an enormous amount of discretion when making time-sharing determinations. And as I stated in the statute, there are a list of factors that the court considers, and that's a good topic for another video. So you all can tune in again and find out what are the factors that the court considers when making a time-sharing determination. In fact, I will make that part 2. And you can tune in maybe tomorrow. I'll try to log on tomorrow and tell you what the factors are. And so Adam has a question. What about if the mother is challenged? Do the courts grant the father sole custody? What do you mean by challenged? Do you mean mentally ill? Or I'm not sure what you mean by challenged. If you are asking if the mother is mentally ill, then the mental health of the parents, of each parent, is one factor that the court considers. So Adam, you'll have to tune in tomorrow and find out what the other factors are that the court considers when making time-sharing determinations. But yes, that's just one factor that the court considers. Okay? Any other questions? Well, I'm so thankful that you all logged on today to watch this video about father's rights and paternity in Florida. Like I said initially, my name's Michelle Lebron. I'm an attorney in Florida. My office is in Osceola County, downtown Kissimmee, right behind the Osceola County Courthouse. And if you need to reach us, we can be reached at 321-800-5195. We got another question. If a father remarries, would the wife have to pay child support? So the short answer is no. That's the short answer. And apparently my grandson's watching. Hi, Jeremiah. If the father remarries, no, only the father's income is considered for child support purposes. And the father's not even his expense. Well, we'll leave that for another video for another day, and I'll explain to you how child support is calculated. But to answer your question, the wife's income is not considered when making a child support determination if she's not the mother of the child. Okay? And so I was saying we can be reached at 321-800-5195. If you feel that this video could benefit someone that you know, please go ahead and share the video with them. And I'm happy to help anyone who contacts us. And as I indicated, we do offer very flexible payment plans. And I'm kind of booked up this week, but we're happy to start scheduling some additional appointments for consultations for next week. And I look forward to hearing from all of you out in Facebook world. Thank you so much for logging in. Have a good night. Bye-bye.